Hello, I'm Jan Painter, and I want to welcome you again to our program, Politics Matters. Our guest today is Professor G. Edward White, David and Mary Harrison Distinguished Professor of Law at the University of Virginia. Professor White holds a BA from Amherst College, a PhD and MA from Yale University, and a JD from Harvard Law School. Dr. White became a member of the UVA faculty in 1972, having clerked for Chief Justice Warren of the Supreme Court. He was twice a senior fellow at the National Endowment for the Humanities, a Guggenheim Fellow, a fellow at the Society of American Historians, and a member of the American Law Institute. Professor White is the author of 14 books and numerous articles on law and legal history. He has won an impressive number of awards and honors, including a final listing for the Pulitzer Prize in History. His many books include History and the Constitution, Collected Essays, The Constitution and the New Deal, and the Marshall Court and Cultural Change, 1815 to 1835. Welcome, Professor White.
Thank you.
Whether reading or watching national news these recent days, and most especially after this 2010 interim election for governor, House, and Senate, one thing catches our attention: the ongoing national conversation among both the American people and their representatives concerning the pros and cons of state versus federal government. How large a footprint should our national government have? When is an overarching protection necessary to assure our rights and privileges? And when might that protection constitute an encroachment on civil liberty? Most of us have an opinion to offer the debate, and as it turned out, our founders most particularly did. Our previous two-part program with Dr. White's colleague, Professor Frederick Schauer, focused our attention on constitutional amendments, what they are and the ways in which they affect our lives as Americans. Today, under Professor White's learned and able guidance, we should like to explore with you an overview of the history of the court, the Supreme Court, taking particular notice of a seminal and transformative moment in its development, the Marshall Court. So, since so much of our national conversation is reflecting concern with our constitutional and judicial roots, and as we all know, we've added 2 new members to the court, let's have a look in the rearview mirror, which is the early days of our republic. Welcome again, Professor White.
Thank you.
Let's begin with the first mention of the Supreme Court, Article 3 of the Constitution, what Alexander Hamilton would call the least dangerous branch of the federal government. For some, a debatable point, to be sure. Start, if you would, Professor, by describing the range and responsibilities of the Supreme Court as enumerated by Article 3.
Well, the article really doesn't say very much at all about either of those questions. It simply says there will be a Supreme Court. Indeed, it provides that the lower federal courts will be established at the discretion of Congress. So conceivably, Congress could have not established any courts any federal courts other than the Supreme Court. Of course, they did. But the expectations for the court at the time of the framing, I think, are very uncertain and perhaps modest. In the first 10 years of the court's existence, it was a comparatively insignificant institution. It decided quite a small number of cases. It did not have a permanent home. It started off in New York, eventually did not have anything like the current chambers in Washington. The justices were primarily occupied with circuit riding in their respective regions. The time that the court actually met in Washington, when it became established under Marshall, was 4 to 6 weeks in the year. So I think it was really up to the court to propel itself into the national picture. The framers were not at all clear about what role it would play.
So the justices and the court discussed and established their own ground rules and really set the landscape for themselves.
Well, of course, the Judiciary Act of 1789 provides the basis for the courts, the Constitution and the Judiciary Act provide the basis for the court's jurisdiction. By that I mean the way cases would be heard by the court, the sorts of cases that would come to the court. And during Marshall's period, there are principally two ways in which cases come to the court. One is from the high courts of the states, and the other is from the lower federal courts. And both of those routes are provided in the Judiciary Act, but there's considerable leeway granted to the court to develop, and that's one thing the court does, is it uses its ability to hear cases that are certified from the lower federal courts to entertain some important cases.
How many justices were originally on the court, and how did they arrive at that number? Who determined that?
Of course, that's provided initially and subsequently by statute. Congress,
Congress
provides the number of justices. It started out with a Chief Justice and 5 associates. So there's a 6-person court. A 7th justice is added in the Marshall Court period. That number remained 7, basically up to the period before the Civil War.
Who was the first Supreme Court justice?
Well, who was the first? The first Chief Justice, was John Jay.
Yep.
Now, one of the things that's interesting about the very early court is there seems to have been an expectation that seniority would play an important role in the court. And the way seniority was worked out was that the Chief Justice was the most senior, even if the Chief Justice had been subsequent, and there were 3 Chief Justices before Marshall, even if that Chief Justice was appointed later than some of the Associate Justices, the Chief Justice would be the most senior. The next most senior justice was done by appointment. So the dates of the appointments of the early justices vary, and their seniority is pitched on the time they're appointed. Now, interestingly enough, seniority is not just reflected in the designations of the various justices, but in the opinion writing process. So in the very early court, the court delivers opinions in the form of unsigned small paragraphs deciding the case. And then the justices render separate opinions, beginning with the most junior justice and ending up with the opinion of the Chief Justice. So seniority is controlling this process.
What types of cases did the court take at the beginning? What areas were they concerned with?
There are largely non-constitutional cases. There's really only one major constitutional case in the 18th century, and that's Chisholm v. Georgia, the case involving the constitutionality of a provision of it's a problem that's solved by the 11th Amendment. It has to do with the capacity of states to sue and be sued in the federal courts. Other than Chisholm v. Georgia, the cases are common law cases, admiralty cases, and not particularly significant cases. And most of the cases come to the court from the lower federal courts, not from the states.
Okay. Let's move and talk about our central focus today, which is the Marbury-Madison decision, and first telling us a little bit about how did Adams come to appoint John Marshall, our 4th Chief Justice?
After the 1800 election, when it's apparent that the Jefferson Republicans are going to win, Adams anticipates that the Jeffersonians will change the composition of the federal courts, because Jefferson has already developed a certain amount of hostility to the judiciary. And so, anticipating this, Adams decides to make a number of very late appointments to federal courts. to, if you will, pack the courts with Federalist sympathizers. This includes the Supreme Court. The then Chief Justice Oliver Ellsworth is in poor health, and there's a need for a successor. And Adams is determined to make a nomination before he leaves term. John Marshall is then Adams' Secretary of State. And Marshall is involved with the nomination process. He and Adams are having conversations. So Adams says, what about this, or Marshall would say, what about this person? And Adams says, no, I don't want him. And what about that person? I don't want him. Marshall proposes about 3 candidates. Adams rejects all of them. There's then a sort of pause, and Adams says to Marshall, I believe I will nominate you. and Marshall doesn't object. So this is a very late appointment. This is right before Adams literally is succeeded by Jefferson. Marbury versus Madison is part of that story in an indirect way. Because what happens is when the Jeffersonians come into power, there are many of the judges in the federal courts are Federalists, and one of them is Samuel Chase. There is a practice by which judges, when they sit on circuit, Supreme Court justices sitting on circuit, sometimes have grand jury proceedings and deliver charges to the grand jury in criminal cases. Chase delivers a couple of charges to grand juries that, in the view of the Jeffersonians, suggest that he's deeply political and prejudiced.
He ends up impeached, does he not?
Right. He ends up being impeached. And it is feared that the next step will be an effort to impeach Marshall himself or some other justice on the Supreme Court. Now, at the same time that Adams makes these appointments to the court, he makes appointments throughout the federal system. And one of the sets of appointments he makes is to basically low-level judges, justices of the peace in the District of Columbia. And one of the persons that he appoints is a person named William Marbury. And in a kind of comical episode, Adams is signing all these commissions of judges. There's a lot of commissions, and Adams is sort of racing through, trying to get them all signed. The understanding is if the commission is signed, the person is entitled to, the new judge designate is entitled to the job, to the office. But then the commission has to be delivered to that judge. The responsibility of delivering the commission falls on the Secretary of State's office, in short, on John Marshall. And he doesn't get around to delivering a number of these commissions before the Jeffersonians take office. One of the commissions that he doesn't deliver is that of William Marbury. So Marbury versus Madison begins with that episode. The Jeffersonians come into power. Madison replaces Marshall as Secretary, James Madison replaces Marshall as Secretary of State. He has these undelivered commissions in his office. And the Jeffersonians decided they're just not going to deliver the commissions because they don't want these appointments to take office. So they don't. And Marbury sues for his commission. He basically argues, I'm entitled to the judgeship, the justice of the peace position, and these people are holding out on me. They're not delivering the commission. And so he brings a writ. The writ is called a writ of mandamus. And the writ is to compel an officer, in this case Madison, to deliver the commission.